News coming to you from our digital desk. We're about to take you live into court. That man there is Ian Rich. He is accused of the I-77 shooting back in April of last year. A neighbor of his was having a party. He saw a truck pull away from that party, so he followed them onto I-77, shot multiple times. He killed the driver, David Perez, 57 years old. His wife, Jackie, was injured but survived. Today was supposed to be his trial, but we believe we're about to get a plea deal in this case. So let's take you live into court.
With his attorneys, Thomas M. Shaughnessy and Thomas E. Shaughnessy. Representing the state of Ohio are Assistant County Prosecutors Kristen Carcutt and Mary Ann Zaki. This matter was originally indicted as an 11-count indictment to which Mr. Rich pled not guilty. It is my understanding that there is a proposed change of plea that Mr. Rich will consider this afternoon. Ms. Carcutt, will you please recite the proposed change of plea for the record?
Thank you, Your Honor. That is correct. The state of Ohio posed two plea options to the defendant. I will place both of those on the record here today, Your Honor. The first option that the state presented to the defense was the defendant could plead to count 1, aggravated murder, together with a 5-year firearm specification, and he could plead to count 5, attempted murder, together with a 1-year firearm specification, with an agreed upon sentence of life with first parole eligibility after 30 years. The second plea offer extended to the defendant, and I believe this is the offer counsel has indicated to the state he wants to accept today. The state of Ohio would move to amend count 1 of the indictment to reflect a charge of involuntary manslaughter pursuant to revised code section 290304. As amended, that is a felony of the first degree, carries a potential term of incarceration of 3 to 11 years, which is 4.5 to 16.5 years with the imposition of Reagan tokes, and up to a $20,000 fine. The state of Ohio would elect that count 1 be the count that includes the Reagan tokes tail for the purposes of this plea agreement. We would then dismiss the remaining specifications other than the 5-year firearm specification attached to count 1. And that must be run prior to consecutive to the sentence for the underlying offense. In count 5, attempted murder, also a felony of the first degree, carries the same penalties as I've previously outlined, that together with the 3-year firearm specification in that count. The 5 and the 1-year firearm specifications as to count 5 would be dismissed. And count 6, discharge of a firearm on or near prohibited premises, that is also a felony of the first degree. It carries the same penalties as I have previously outlined. The state would move to amend that count by deletion of the firearm specifications. It is agreed by this plea agreement that this court would sentence the defendant to a term of incarceration between 35 and 40 years to the discretion of the court, with the parties given the opportunity to argue for one of those numbers between 35 and 40 to the court. Other than what's been placed upon the record here today, no threats or promises have been made to reduce this plea, and the state is in compliance with its obligations with respect to Marcy's Law and victims' families present here in the courtroom today.
Thank you, Ms. Carcutt. Mr. Shaughnessy, is that your understanding of the proposed change of plea?
Thank you, Your Honor. For please the court, yes it is. We have discussed both of the options as indicated by Ms. Carcutt with our client. We would, as she indicated, elect for the second option, or what we would call the flat tire or definite sentence option. Mr. Rich is aware of all of his constitutional rights. He's aware of the possible penalties that you may impose upon him. I believe he'll enter the plea here this afternoon knowingly, intelligently, and voluntarily. Would you like him to remain seated or seated?
He can remain seated.
Thank you very much, Your Honor.
Okay, Mr. Rich, I'm going to ask you a series of questions at this point. Purpose of these questions is that if you do decide to change your plea, the court needs to be satisfied that you do so knowingly, voluntarily, intelligently. You understand the charges, your constitutional rights, and the maximum penalties that are associated with each of the charges that you're considering pleading to today, okay? Now, I'm going to go over, when I go over all the sentencing ranges, I'm going to go over all the sentencing ranges for each charge. I will tell you that I intend to accept the recommended 35 to 40 years but I am required to advise you of the total possibility of penalties that are associated with these charges, okay? Please state your name and your age. Please state your name and your age.
Ian Rich, 30 years old.
Okay. Mr. Rich, what's the highest level of education that you've completed?
Associates,
Okay. Can I make an assumption you can read and write proficiently?
yes.
And you understand that Mr. Shaughnessy's are representing you adverse to the state of Ohio in this matter, correct?
Yes.
When they are explaining to you what their state of negotiations is with the state of Ohio, do you understand what they're saying?
Yes, Your Honor.
Do you understand the nature of the charges that you are considering pleading guilty to today?
Yes.
Have any threats or promises been made to you to induce you to change your plea?
No.
Okay. And do you understand that the court has not made any promises regarding sentencing?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication that could in any way impair your ability to fully understand what's happening in court today?
No.
Okay. Are you satisfied with the representation that Mr. Shaughnessy has provided in this matter?
Yes.
Are you currently on probation, community control sanctions, parole, or post-release control in any other case?
No.
Okay. Are you a citizen of the United States?
Yes.
Okay. I'm going to go over your constitutional rights. If you understand what I'm saying, when I pause, please say yes so the court reporter can take your response down. If you are not sure, or you want a minute to speak to Mr. Shaughnessy, at any point, let me know, and you can have as much time as you need, okay? Do you understand that you are presumed to be innocent, but by entering pleas of guilty, you admit to the facts and your guilt in this matter?
Yes.
Do you understand that you have a right to a trial, either to a jury or directly to the court?
Yes.
Do you understand that if you chose to go to trial, it would be the state of Ohio's burden to prove you guilty beyond a reasonable doubt?
Yes.
Do you understand that if you chose to go to trial, you have the right to confront and cross-examine all of these state's witnesses against you?
Yes.
Do you further understand that you have the right to call your own witnesses and the court would compel them to be here on your behalf?
Yes.
Do you understand that if you chose to go to trial, you have the right to remain silent and you could not be made to testify in this matter?
Yes.
And do you understand that if you chose to go to trial and exercise your right to remain silent, the state of Ohio could not use your silence to prove your guilt in this matter?
Yes.
Do you understand that the court can move to judgment immediately after you enter a plea?
Yes.
Do you understand that you have the right to be represented by an attorney throughout these proceedings?
Yes.
Finally, do you understand that other than your right to be represented by an attorney, you are waiving those constitutional rights that I just outlined by pleading guilty in this matter?
Yes.
So based on these statements of the prosecuting attorney and your attorney, I believe it is your intention to plead guilty to count 1, involuntary manslaughter, a felony of the first degree in violation of Ohio Revised Code, section 2903.04, section A, with a 5-year firearm specification. I believe that you also intend to plead guilty to count 5, attempted murder, a felony of the first degree in violation of Ohio Revised Code, section 2923.02, 2903.02, section A, containing a 3-year firearm specification. Finally, I believe you intend to plead guilty to count 6, discharge of a firearm on or near prohibited premises, a felony of the first degree in violation of Ohio Revised Code, section 2923.162, section A3. Each of these counts that you are considering pleading to is a felony of the first degree. Felonies of the first degree are punishable by a term of incarceration of 3 to 11 years and or a fine of up to $20,000. Now, I'm going to read to you a law we refer to as the Reagan-Tokes Law. And then we're going to do some simple math just to make sure we all understand each other. Senate Bill 201 implements an indefinite sentencing system for non-life felonies of the first and second degree. The sentencing judge will impose a minimum term from within the currently established sentencing range and a maximum term of an additional 50% of the minimum term imposed. Release is presumed to occur at the expiration of the minimum term. However, the Department of Rehabilitation and Corrections may, under certain circumstances, rebut that release presumption and impose additional prison time up to the maximum term. Okay, now, Mr. Rich, there's 3 felonies of the first degree that you are considering. The state has indicated that they intend to attach what we call the Reagan-Tokes tail to the first count, involuntary manslaughter. So, for the sake of our conversation, I'm going to pick a hypothetical number that you should read nothing into. But if the state were to come up with a number of 6 as a sentence on count 1, 6 years, the department is able to make certain findings to impose an additional 50% more time. Can you tell me what 50% of 6 is?
3 years.
Okay, so if, on that particular count, the minimum, the hypothetical minimum were 6, what would the maximum be? So it would be 6 plus the 3.
9 years.
Right, okay. Now, on the Reagan-Tokes law, some other things you should know. The department can make that finding more than once as your outdate approaches, but they can never exceed the maximum time. There is a presumption that the department will make towards what the trial court sentences you to, okay? So and you understand the concept of a presumption, right? Okay, so what they would have to make certain findings in order to impose more time on you while you're in the institution, okay? So again, while I intend to accept the recommendation, the court, or excuse me, whatever the court states for a sentence, the department can still add an additional 50% of count 1 to the time that you're there, okay? You understand that?
Understand.
Okay. Now, upon leaving the institution, because it's a felony of the first degree, you'll be subject to a mandatory minimum of 2 years and maximum of 5 years of post-release control. Now, while on post-release control, if you were to violate the terms of post-release control, the Adult Parole Authority can return you to prison for up to 1/2 of the original sentence imposed. Further, if you were convicted of or pled guilty to a felony while on post-release control, the sentencing judge in the new case can impose an additional consecutive term of 1 year or whatever time remains on post-release control, whichever is greater. Finally, if you were to fail to report to your supervising officer, you could be charged with escape, and escape is a felony in the state of Ohio, okay? At this point, do you have any questions for me about these charges, your constitutional rights, or the sentencing guidelines that I have just outlined for you?
No.
Ms. Carcutt, are you satisfied that I've complied with the requirements of Criminal Rule 11?
With respect to explaining the felony of the first degree and the Reagan-Tokes, with respect to the remaining specifications or penalties in total, I don't think the court covered that.
Okay. So, again, I do intend to accept the recommendation. However, the court could sentence you. The specifications that are in here, the 5-year, those have to run consecutive and the first part of the sentence to be served, and the court has no discretion over that. So count 1 has a 5-year specification, count 5 has a 3-year specification, and count 6 does not have a specification. But those are, so the court has no discretion over those, and those have to run consecutive, and it's the front end of the sentence where that has to be served. I have to also advise you that the court can make certain findings and run everything consecutive. Okay. Ms. Carcutt, Are you satisfied that the court has complied with the requirements of Criminal Rule 11?
Yes, Your Honor, and I would just note that I know the court's indicated that it will follow our agreed sentencing range, and essentially it only goes to 41 years out, all total, outside of that range.
Okay, thank you. Mr. Shaughnessy, are you satisfied that I've complied with the requirements of Criminal Rule 11?
I am, Your Honor.
Okay, thank you very much. Let the record reflect that the court is satisfied that Mr. Rich has been informed of his constitutional rights. He understands the nature of the charges, the effect of a plea, and the maximum penalties which may be imposed. Mr. Rich, how do you plead to count 1 of the indictment, involuntary manslaughter, a felony of the first degree with 5-year firearm specification?
Guilty.
How do you plead to count 5, attempted murder, a felony of the first degree with a 3-year firearm specification?
Guilty.
How do you plead to count 6, discharge of a firearm on or near prohibited premises, a felony of the first degree?
Guilty.
Let the record reflect that the court finds that Mr. Rich has knowingly, voluntarily, intelligently, and with a full understanding of his rights entered his change of plea. I make a finding of guilt to the offenses of involuntary manslaughter, a felony of the first degree in violation of Ohio Revised Code Section 2903.04, Section A, with a 5-year firearm specification pursuant to Ohio Revised Code Section 2941.146A. I make a further finding of guilt to the offense of attempted murder, a felony of the first degree in violation of Ohio Revised Code Section 2923.02, 2903.02 Section A, with a 3-year firearm specification pursuant to Ohio Revised Code Section 2941.145A. I make a further finding of guilt to the offense of discharge of a firearm on or near prohibited premises, a felony of the first degree in violation of Ohio Revised Code Section 2923.162, subsection A3. As a result of the plea negotiations, the remaining counts are hereby dismissed. At this point, Mr. Rich, I am going to refer you to the court's probation department for a pre-sentence investigation report. I'm also referring you to the court psychiatric clinic for a mitigation of penalty report. We are going to have a sentencing hearing on this matter on the 5th of June at 9 a.m. Is there anything else for the court on this matter for today?
No, thank you, Your Honor.
Thank you. Mr. Shaughnessy?
No, Your Honor, thank you very much.
Okay, thank you. We're adjourned.
Dan DeRose with 19 News. As you see Ian Rich there being taken out of the courtroom, we'll see him back in early June for sentencing. He has changed his plea, and it comes on a day when his trial was set to begin. Our Brian Duffy, and we're getting a look at some of the family members who were in court. Our Brian Duffy has done some extensive reporting on the mental capacity and mental issues that Ian Rich was suffering from. Police in Newburgh Heights, where he lived, had been called to his home a number of times for a wide range of things, including the belief that satellites were following him, that the FBI was following him. We've even got on video, body cam video, police from Newburgh Heights at his home asking that he turn in his weapons, that they lock him up there at the police station, and that obviously happened before the murder on I-77. And again, it was a bizarre set of circumstances. It was a neighbor who was having a party. Leaving that party was this couple, the Perez husband and wife. They got on I-77. He decided, for whatever reason, to chase and follow them onto 77. And then he fired multiple times into their car. It killed David Perez and injured his wife, Jackie. And so now he had two options on the table that the state was willing to give him. He could have pleaded guilty to aggravated murder, and he could have been sentenced to life in prison with the first chance of parole at 30 years. But instead, he takes the involuntary manslaughter and attempted murder, and he will be given a flat sentence of 35 to 40 years in prison. As you heard, he's 30 years old, so if he gets the minimum, he'll be 65 by the time he gets out of prison. We'll have a complete wrap up on this and all of the day's news coming up at 3 o'clock. That's a half an hour from now on Channel 19. Until then, I'm Dan DeRosa with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media at Cleveland 19 News.